All right, so now we proceed to the very last um, session or midterm, and this is about arraignment and plea plus pre-trial. Okay, if you observe Rule 116, the arraignment and plea is separated from Rule 118, the pre-trial. But in practice, for one, the continuous trial rule, we are mandated na isahin natin ang arraignment and plea at saka free trial. So that is why if you will observe later on when you do your practice, in the court order, siniset yan na yan ng court na isang araw lang or isang session lang. Okay? So, well, nasa? Okay. So, siniset na yan siya ng isang araw lang. Isang incident lang or court incident lang ang arraignment at saka yung pre-trial. So, it's very short actually. So, let us begin with Rule 116, arraignment and plea. Are you ready? Okay. So, this is still covered sa exam. Before arraignment, the court shall inform the accused of his right to counsel and ask him if he desires to have one. Unless the accused is allowed to defend himself in person or has employed a counsel of his choice. So the court must assign a counsel de officio during the arraignment and plea. So kapag wala kang lawyer at that time, then the court must assign a counsel de officio to assist the accused for this stage. Pwede bang proxy? Pwede bang mag-special power of attorney ang accused na ibang tao yung mag-enter ng kanyang plea? The answer is no. The accused must personally present himself and he must personally enter his plea. Okay? It cannot be delegated, ha? It cannot be delegated. So, the court's concern here is that if walang abogado yung accused during arraignment, okay, kailangan na mag-assign ang lawyer or ang judge ng abogado na mag-a-assist sa kanya. Pero kung meron siyang abogado, then there's no problem. Okay? Or if there is PAO, usually, ang ginagawang lawyer assigned for the accused na walang abogado during arraignment is the PAO. Pero may choice rin ang judge na mag-appoint ng any lawyer na hindi PAO as counsel. Okay? Because it is mandated under 116. Okay? In the case of People versus Pangilinan, GR number 171020, March 14, 2007, penned by Justice Chico Nazario. Okay? While the arraignment of appellant was conducted after the cases had been submitted for decision, the error is non-prejudicial and has been fully cured, since appellant's rights and interests were not prejudiced by this lapse in procedure. Bakit? Ano palang nangyari dito? The accused here was relatedly arraigned. And the Supreme Court said that even if it happened that way, it did not prejudice him. This procedural defect was cured when his counsel participated in the trial without raising any objection that his client had not yet been arraigned. In fact, his counsel even cross-examined the prosecution's witnesses. His counsel's active participation in the hearings is a clear indication that he was fully aware of the charges against him. Otherwise, his counsel would have objected and informed the court of his blunder. Moreover, no protest was made when appellant was subsequently arraigned. So the parties did not question the procedure undertaken by the trial court. This is unique, ha? Because nakalimutan yung pre-trial. But nevertheless, the trial proceeded, no objection on the part of the accused. Later pa, So the Supreme Court said it's already waived on your part. Okay, so Rule 116. That's Rule 116, Section 6. Let's now go immediately to Rule 116, Section 7. The court, considering the gravity of the offense and the difficulty of the questions that may arise, shall appoint as counsel de officio only such members of the bar in good standing, who, by reason of their experience and by reason of their ability, can competently defend the accused. May trial na ba sa arraignment? The answer is wala pa. The accused will actually be informed of the formal charge. He will be read by the court of the information, and then he will be asked guilty or not guilty. Then the accused will enter his plea. Okay? So that is the reason why there is a need for an assistance. Kasi baka iba yung i-enter na plea sa gusto talaga or sa desire ng accused. That is why he needs to be assisted. So there are instances na, or there are areas na wala talagang abogado. That is why we need lawyers. Okay, Rule 116 Section 7 says that in localities where members of the bar are not available, the court may appoint any person, resident of the province, and of good repute for probity and ability to defend the accused. Okay? So, yeah. But I haven't witnessed one so far. Like, kung nabot ko dito, ako siguro may appoint, di ba? So, yan. Rule 116, Section 8, whenever a counsel de officio is appointed by the court to defend the accused at the arraignment, he shall be given a reasonable time to consult with the accused as to his plea before proceeding with the arraignment. So, bigyan ng court ng time kasi first time yan nila nakita at that particular instance. Okay? The counsel de officio is appointed on the spot. Okay? Kasi wala nga siyang abogado and the court cannot delay the proceedings. So, Attorney AAA, ikaw ang mag-assist ngayon sa arraignment para sa accused na ito. Okay? I will give you a reasonable time to talk with the client, and that is allowed. Actually, that is required under Rule 116 Section 8 para mag-usap muna sila, ma-explain ng maayos ng counsel de officio ano yung implication ng proceedings na yan. Okay? When is arraignment and plea held? As a general rule, Rule 116 Section 1 letter G says that the arraignment shall be held within 30 days from the date the court acquires jurisdiction. Okay, jurisdiction over the person of the accused, meaning to say from the moment na na-arresto yung akusado. Unless a shorter period of time is provided by special law or Supreme Court circular. Okay? The time of the pendency of the motion to quash, motion for appeal of particulars, which we will discuss later, or other causes justifying suspension of the arraignment shall be excluded in computing the 30-day period. Okay? Pero pag wala, then you have to observe that. If the accused is not brought to trial within the time limit required by Section 1G, Rule 116, and Section 1 as extended by Section 6 of Rule 119, the information may be dismissed on motion of the accused on the ground of denial of his right to speedy trial. So please take note of that. So balikan lang natin ha, ano yung rule dito. Ang sabi dyan, if hindi na-observe ang 30-day period from the time na na-aresto siya, dapat nagkaroon na ng, nagkaroon na ng pre-trial or arraignment. If the accused is not brought to trial within the time limit required by Rule 116 Section 1G, meaning to say kapag hindi pa siya na-arraign within 30 days from the date the court acquires jurisdiction over the person of the accused, then what will happen? Or as extended by Rule 119 Section 6, ano ba yung extension na binigay ng Rule 119 Section 6? This is covered sa sa finance, pero tingnan lang natin. The extended time limit, notwithstanding the provision of Section 1G, Rule 116, and the preceding Section 1 for the first 12 calendar month period following its effectivity, The time limit with respect to the period from arraignment to trial imposed with the said provision shall be 180 days. But this is for the trial na. Ang ang point lang natin for now is that within 30 days from the moment na naaresto si accused, because that is the time when the court acquires jurisdiction over his person, dapat naari na siya. If not, then the accused or the information may be dismissed on motion of the accused on the ground of the denial of their right to speedy trial. The accused shall have the burden of proving the motion, but the prosecution shall have the burden of going forward with the evidence established, okay, the exclusion of time under Rule 119, Section 3. The dismissal shall be subject to the rules on double jeopardy. Kapag napadismiss, hindi mo na pwedeng i-refile because that will tantamount to the violation of the rule against double jeopardy, which is guaranteed by Article 3. Okay? Failure of the accused to move for dismissal prior to trial shall constitute a waiver of the right to dismiss under this section. Okay, so that is an available remedy for you. If you fail to raise that, then that's your fault. No provision of law on speedy trial and no rule implementing the same shall be interpreted as a bar to any charge of denial of the right to speedy trial guaranteed by Article 3, Section 14, Paragraph of the 1987 Constitution. When the accused is under prevention or preventive detention, meaning to say under warrantless arrest, his case shall be raffled and records transmitted to judge to whom the case was raffled within how many days? 3 days from the filing of the information or complaint. And the accused shall be arraigned within 10 days from the date of the raffle. So please take note of that because there will be a remedy if it is observed. Where is the arraignment and plea held? Before the court, of course. But which court? Where the complaint or information was filed or assigned for trial. That is Rule 116, Section 1. What happens of a case if a case is tried without arraignment? That is irregular. But again, if you fail to object, then People versus Pangilinan will tell you that it can be waived. Okay? So, also in People versus Cabale, May 8, 1990, nag-pre-trial na pero walang arraignment. The parties presented evidence when the case was about to end. They noticed na hindi pa pala na-arraign. So there was an irregularity. But the error was cured when counsel for the appellant entered into trial without objecting that his client had not yet been arraigned. Okay? So you have to take note of the stage-by-stage proceeding. After the arresto, within 30 days, kailangan na-arraign na siya. Okay? Kung warrantless arrest ang nangyari, okay, his case shall be raffled and its records transmitted to the judge to whom the case was raffled within 3 days from the filing of the information. And the accused shall be arraigned within 10 days from the date of the raffle. Okay? So, yeah. For a while plus, okay. Now, we are done with the. Let's now go to can the arraignment be suspended? The answer is found in Rule 116, Section 11. Upon motion by the proper party, the arraignment shall be suspended in the following cases. First, if the accused appears to be suffering from an unsound mental condition, which effectively renders him unable to fully understand the charge against him and to plead intelligently thereto. In such case, the court shall order his mental examination and, if necessary, his confinement for such purpose. If there exists a prejudicial question that could also be a ground for suspension, and a petition for review of the resolution of the prosecutor is pending at either the Department of Justice, okay? Wala ng Office of the President dyan, OJ lang yan siya. Now, and provided that the period of suspension shall not exceed 60 days counted from the filing of the petition with the legitimate office. Now, how is arraignment made? Paano ba ina-arraign yung akusado? Rule 116, Section 1, Paragraph A says that the arraignment shall be made in open court by the judge or clerk by furnishing the accused with a copy of the complaint or information, reading the same in the language or dialect known to him, binabasa yung information. Actually, hindi na yun siya binibigyan kasi binigay na yun sa ahead of time sa abogado. So, basically, or sa accused, nangyayari lang sa arraignment is babasahin ngayon ng court through the court interpreter yung laman ng information in the language or dialect na known sa accused. And the court will ask him whether he pleads guilty or not guilty. The prosecution may call at the trial witnesses other than those named in the complaint or information. So, is attendance during arraignment required? On the part of the accused, of course, he must be present at the arraignment and must personally enter his plea. Hindi pwede na mag-special power of attorney ka. But with respect sa private offended party, kailangan ba siyang nandun during arraignment? Required pa rin, yes, to appear at the arraignment for purposes of plea bargaining, determination of civil liability, and other matters requiring his presence. In case na wala talaga siya, can the arraignment proceed? The answer is yes. The court may allow the accused to enter plea. In fact, the court may allow the accused to enter a plea of guilty to a lesser offense, which is necessarily included in the offense charge with the conformity of the trial prosecutor alone if wala yung private complainant. Okay? Meron bang penalty kapag wala ang private complainant during the arraignment? The answer is wala. Pero necessary talaga na dapat nandun siya for purposes of plea bargaining, possible plea bargaining or determination of civil liability. Pero pag wala siya, nandiyan naman yung public prosecutor. So, yan. Pero kapag ang accused ang wala, hindi talaga matutuloy yung arraignment. Bakit? Kasi yung accused mismo dapat ang mag-enter ng kanyang plea. Okay? And if nasa if under bail ka, okay, bonded, and you did not appear, that you violated your, you violated your bond, the undertaking of your bond. If that happens, the court may forfeit your bond. Okay? And if the bondsman is other person than the accused, then the bondsman will be given the period to explain and produce the person of the accused. Okay? You learn that in your bail discussion. So both arraignment and plea shall be made of record, but failure to do so shall not affect the validity of the proceedings. Okay? Sige. Question from the class? So we are done. Let us now go to plea bargaining. Plea bargaining. Diba sabi natin, this happens in the arraignment. Mag-plea bargain ang accused. When the accused pleads guilty, okay, di ba pangatanon man siya, guilty or not guilty. If the accused pleads guilty, but a lesser offense, then at the arraignment, what will happen? Rule 116, Section 2 is the rule. The accused, with the consent of the offended party and the prosecutor, may be allowed with the trial court to plead guilty to a lesser offense, which is necessarily included in the offense charge. It may be allowed. Basta masugot lang ang private complainant. If the accused pleads guilty but to a lesser offense, other than the charge after arraignment but before trial, then the accused may still be allowed to do that. Okay? After withdrawing his plea of not guilty. No amendment of the complaint or information is necessary if that happens. Now, when the accused pleads guilty to a capital offense, like it is punishable by life imprisonment, reclusion perpetua, or kaning death, the court shall conduct a searching inquiry into the voluntariness and full comprehension of the consequences of his plea, because this is not a joke, and require the prosecution to prove his guilt and the precise degree of culpability. The accused may present evidence in his behalf. Okay, so yeah. And then if the accused pleads guilty to a non-capital offense, then the court may receive evidence from the parties to determine the penalty to be imposed. So, careful lang ang court kapag nag-plea siya ng guilty to a capital offense, which is death, reclusion perpetua, or life imprisonment, because this time, the rules require the court to conduct a searching inquiry. And what do you mean by searching inquiry? A searching inquiry, okay, it would be well for the court, for instance, to require the accused to fully narrate the incident that spawned the charges against him, okay, or by making him reenact the manner in which he perpetrated the crime, by causing him to furnish and explain to the court missing details of significance. The trial court should also be convinced that the accused has not been coerced or placed under the state of duress, either by actual threats or physical harm coming from malevolent or avenging quarters. And this it can do such as by ascertaining from the accused himself the manner in which he was subsequently brought into the custody of the law. Pwede rin na the court will ask whether he had assistance of competent counsel during the custodial or preliminary investigations, and ascertaining from him the conditions under which he was detained and interrogated during the upper stage of investigation. Likewise, a series of questions directed at defense counsel as to whether or not the said counsel has conferred with and completely explained to the accused the meaning of a plea and its consequences. Kasi hindi ito biro eh. And it would be a well-taken step along those lines. That is in the case of People versus Estomaca. According to one commentator, once the accused pleads guilty to a capital offense, a regular trial court shall have to be conducted. Okay, or a regular trial shall still be conducted. The only effect of a plea of guilty, if ever, is to serve as an additional mitigating circumstance in case the penalty imposable is less than an indispensable penalty. If the guilty plea is entered before the prosecution starts to present evidence. Ano ba ibig sabihin niyan? Kahit mag-plea siya ng guilty, because of the weight of the punishment here, diba? The rule requires that the court should conduct a searching inquiry. And even if so, the trial will still proceed. Okay? Kaya lang, ano yung effect na nag-plea siya ng guilty even if nag-conduct na ng searching inquiry? It will be counted as a mitigating circumstance on the part of the accused. Okay? Mitigating, mag-lessen yan sa penalty niya. Okay? But if the penalty is not capital offense, then the court may receive evidence from the parties to determine the penalty to be imposed. Okay? So, yeah. What if during plea bargain or during the arraignment, he enters the plea of not guilty? Then a plea of not guilty shall be entered for him. Okay? And the trial will proceed. What if the accused refuses to plead or makes a conditional plea? Then the effect is that a plea of not guilty shall be entered for him. What if the accused pleads guilty but presents exculpatory evidence? Under Rule 116, Section 1, Paragraph D, his plea shall be deemed withdrawn and a plea of not guilty shall be entered for him. Okay? So again, because of strong presumption of innocence on the part of the accused. After a plea of not guilty is entered, then the accused shall have at least 15 days to prepare for trial. Magka-trial na po tayo. And the trial will be discussed in the finals. The time limitations provided under Rule 119, Section 2 and Section 1 shall not apply for special laws or circulars of the Supreme Court provide for a shorter plea. Okay? For a while, plus Now, let's go to the case of People versus Mendoza. 231 Scra 264. During the arraignment, the accused pleaded guilty. Instead of pronouncing judgment, the court conducted trial. The prosecution failed to present evidence that the accused is guilty of the crime. So the judge acquitted the accused, even if during the arraignment he pleaded guilty. The prosecution argued that the judge should not have acquitted him because in the first place he already pleaded guilty. Tama ba yung ginawa ng judge? The Supreme Court said that yes, the acquittal was proper. Bakit? When the accused pleads guilty to a non-capital offense, the court may receive evidence from the parties to determine the penalty to be imposed. This rule is at most directory. There is no rule which provides that simply because the accused pleads guilty to the charge that his conviction automatically follows. However, there is something wrong here. The correct procedure is for the judge to order the withdrawal of the plea of guilty and substitute it with a plea of not guilty. This principle has been embodied in Rule 117 or Rule 11, 116, Section 1, Paragraph. Yan lang yun. Pero as to the judgment of acquittal, it's correct. People versus Gumimba. GR number 174056, February 27, 2007, pen by Justice Tinga. When a plea of guilty to a capital offense is entered, ano nga yung mangyari? There are three conditions that the trial court must observe. First, it must conduct a searching inquiry into the voluntariness and full comprehension by the accused of the consequences of his plea. It must require the prosecution to present evidence to prove the guilt of the accused and the precise degree of his culpability. And third, it must ask the accused whether he desires to present evidence on his behalf and allow him to do so if he so desires. So, yeah. Okay. Let me see if I miss something. What will happen if the accused dies after arraignment? Okay. It shall extinguish the civil liability. Alright, that is Rule 111, Section 4. Just a review. It shall extinguish the civil liability arising from the debt. However, the independent civil action may be continued against the estate, okay, as the case may be. So we learned that before. Okay. Now let's go to pre-trial. Pre-trial. When is pre-trial conference conducted? Now it is conducted immediately after arraignment. That is the directory of the directive of the Supreme Court in the continuous trial. Direction na after arraignment, diretso pre-trial. Okay? But can that be separated, the arraignment and the pre-trial? Of course, it can be because Rule 116 man ang arraignment, Rule 118 man ang pre-trial. These are two different stages. Inisa lang natin for purposes of continuous trial. Okay? Okay. So, when a person is arrested pursuant to a valid warrant of arrest, kailangan ang pre-trial nangyari within 30 days from the date the court acquires jurisdiction over the person of the accused. So, preferably, ang arraignment at saka ang pre-trial, isagin mo na yan because same period man ang deadline. Unless a shorter period is provided for in special laws or circulars of the Supreme Court, order a pre-trial conference. When a person was arrested without a warrant within 10 days after arraignment. Okay, but now it's already combined. What is the purpose of pre-trial? This is to consider the following: plea bargaining, stipulation of facts, marking for identification of evidence of the parties, waiver of objections to admissibility of evidence, modification of the order of trial if the accused admits the charge but interposes a lawful defense, and such other matters as will promote a fair and expeditious trial of the criminal and civil aspects of the case. If the counsel for the accused, that is Rule 118, Section 1. If the counsel for the accused or the prosecutor does not appear at the pretrial conference and does not offer an acceptable excuse for his lack of cooperation, the court may impose proper sanctions or penalties. Ito yan sa pretrial. Sa arraignment, yun yung iba rin yung effect niya. But considering that we are now combining arraignment and pretrial, then you observe also these sanctions. All agreements or admissions made or entered during the pretrial conference shall be reduced in writing and shall be signed by the accused and counsel. Otherwise, they cannot be used against the accused. The agreements covering the matters referred to in Rule 118, Section 1 shall be approved by the court. So, after the pretrial conference, the court shall issue the so-called pretrial order, reciting kung ano yung nangyari doon, ang stipulations, and the evidence na namarkahan at saka na-identify ng mga witnesses. Such pretrial order shall bind the parties, limit the trial to matters not disposed of, and control the course of the action during the trial. So that will, the pretrial order will be the controlling document that will guide us in the subsequent stages of incidents in court. Okay? Unless the pretrial order is modified by the court to prevent manifest injustice. Okay? The trial shall commence within 30 days from receipt of the pretrial order. Remember, the time limitations provided under Rule 119, Section 2 and Section 1 shall not apply where special laws or circulars of the Supreme Court provided for a shorter period of trial. Okay? What else? Let me check. May na-miss ako. So we are done with our coverage for the exam. God bless for your exam, and I hope that even we have a very short period to cover everything, at least we have covered it. Okay, so if you have questions, line is open even before what's the start of the exam. I can still reply. Okay, but once the exam is commenced or has commenced, then pasensya na. Okay, so God bless and good luck.